But I just want to say that this episode that we are doing today could be addressed to a number of our viewers, but particularly to those who are in the process of making a will, who are tasked in doing a will. It's also addressed to who would possibly be the beneficiaries.
And it's very difficult to take a hard call. So I had started the process thinking I'll be responsible and I will help my next generations to have less issues.
How do we see death? How do we face the fears of death? And these are questions, as you so beautifully explained when you were going through, things you never thought about that put it in context. So thank you for putting some flesh to her question.
The law is like that. Law has provided provision that if a will is made when a person is not married, once he marries, then the will will become void and he will have to make a fresh will. Their operation of the bank account either are survival. So if a person passed away, the other joint account holder can continue that account.
So the bank will ask for this?
Yeah.
The bank asks for
already it is there.
It is there. Okay.
It is already there. So, I myself and my wife have joint accounts. All our accounts are joint. So if I am not there, if I pass away, my wife can operate that joint account.
Welcome back to our second episode of Legal Will. I hope you enjoyed the first episode and you must be waiting for more. So let's get right into it with our panelists, Mr. Robinson D'Souza and Father Juventius Andrade. So that brings me to my next question, saying that if as a parent, I want to be fair and just, and I also want to be responsible to sort this out among my kids. Now, I can write something in my will and let the bomb go loose when I die, which means I just defer all the confrontation and the hostility not in my lifetime. Or do you think it's wise to actually sit the kids down and say, this is what I'm thinking, so-and-so's taken care of me, the so-and-so's put in financially into making this house, whatever it is, we have debts to pay, a child needs more help than the other. How advisable is it to bring your immediate legal heirs into the conversation before you die, or is it advisable after you die?
I like to understand this or respond to this on two levels, and then I'll pass it on to our professional. First of all, the testator is giving this to the beneficiaries. All that the beneficiaries receive, they have not earned it. It's a free gift. Sometimes the children can come with a sense of entitlement when they have not earned or worked towards it. And so they will clear the pitch. The graceful thing would be to say, whatever I received is all bonus. Because after all, I have not earned it. It's an inheritance that I've received, whether it's little or great. The second is, should you tell them when they're alive that this is going to be the nature, the point that you made. Honesty is the best policy. Now, it can cut both ways. There's no fixed law about it. On one hand, if the relationships are good, it will work out. There's a lovely French proverb. When there is trust and love, even 1,000 objections will not create a doubt. But when there is no trust and love, even 1,000 proofs will not create a certainty. Just apply this to all relationships that you have. It will resonate with you. So, if there is mutual trust and love, you being open and honest about it, everyone is on board if they're on the same page. But if there is doubt, sibling rivalry, unspoken hatred, the dynamics that come after they're married because new circle of friends, in-laws, and that initial where there was bonding over there, that pot gets churned so much. And if they come to know this is how it's going to be, they are going to, some of them, will swoop like vultures and put pressure on the one to change it so that they will be favored. How is it that we are getting less than my brother or sister? What about your grandchildren? You've given favor to this and you've given favor to that. And all hell breaks loose because the demons of jealousy and greed come into the picture. So as I said, it's a call. I'm not willing to give a hard and fast rule. The reason I'm saying this on a public forum is so that because this game is being played out in far too many families, and we need to become aware of it and address it. And that's one of the aims of this talk show, to take issues that are there, which are not comfortable to face and talk about it, and yet bring it in a public forum so that as this is being spoken, it's also a wake-up call to see what are our relationships and how are they being played out in the terms, especially when the legal will is being raised.
Mr. Robinson.
Yeah. Further, I fully agree with you regarding one aspect which you mentioned. What the children get under the will of their parents is a gift for them. The parents work hard, save all these things, then when they are no more, they make arrangement so that the children will succeed to the assets and properties which they have accumulated for the sake of the children. That doesn't mean that, according to my experience, the assets and properties should be equally distributed among children. It depends upon circumstances. I have come across several such incidents in my own life. In one case, father had 2 sons and 1 property. He loved his eldest son. It's for him. And he made a will giving the house to his elder son. He announced it at home very next day. The second son was a fighter, tough. He started quarreling. And next day, he took the second son took the father to a lawyer, made a will giving the house to him, bequeathing, and got the will registered. Look at the situation. Father fell ill on account of the shock. And shortly, in no time he became a vegetarian and died so. Imagine his last days on the bed, how much he has mentally and emotionally suffered.
So this is a moral conflict, yeah.
Similarly, I have come across several cases like this because I handled. This I learned. Another case which I handled. Yeah. A person had properties, a big palatial house, an educated person, 2 daughters, well educated, good job. And he requested me to make his will. I went and discussed with him when he was alone, though he was bedridden at that time. When I met him, he held my hand. Make my will as early as possible. I am going to die, make my will. I said, I will help you. Give me details. And I sent all those. So when he was alone, I went and recorded what he wanted. He wanted to give his property during his lifetime, wherever it is situated, to his wife. He said, I want to give everything to my wife, make a will. I said, that was, I recorded, I met him again, same condition. But wife's condition, this one situation, her intention was that it should be gifted to 2 daughters. Property was not going anywhere. He was almost on the deathbed with a broken hip. He wanted to give it to his wife as a gift. So under the will, not a gift. But wife's intention was to divide the property during his lifetime among her 2 daughters, which he did not agree. I said, I can't make a will. Earlier they had asked me my fees. I mentioned my fees for all this, including registration and all, 25,000, because property was here as well as in Mangalore, immovable property. And he was bedridden. That's just a nominal fee I mentioned. They went, he said, you can go to any other lawyer. I had drafted the document also given to them. They went to another lawyer. He said, I will do it, as you say. 1,25,000. And they came back to me, sir, he is demanding 1,25,000. And you said 25,000. I said, can you make for 25,000? Yes, I will make for 25,000. But as your husband has said, not as you say. As I came to this premises, somewhere here, very close to, I have had an occasion to make a will. Husband died. The testatrix owns it. 3 children she has. Eldest son is mentally affected. 2 daughters they have, both are engineers, they are working. And in that house, there are 3 portions, ground floor, 1 unit and another unit. Since one son, the eldest son can't earn in spite of his education, he just said, oh, something has happened, mental disorder. So she wants to give that portion to him so that he can live in one portion and rent out the other portion and earn something out of rent and survive after her death. And the upstairs she has given one portion to one daughter and the portion to another daughter. But the quarrel between children, one of them wants the ground floor itself. If ground floor is given, how this person can survive there? Since he is not mentally that strong, how can he climb to the upstairs? These are the things that will come. The equal distribution will not make. One more case, son is mentally broken. He can't do anything. Fully affected, mental disease and all. He can't handle himself at all. And the father naturally wants to give him more. Equal distribution, equity doesn't come there. That's your child. They have to take care of them when there are no more in these 2 cases. Equally, this will not come.
Equity.
For somebody, something has to be given more in these cases. And imagine the condition of the parents when they do it. They don't do it deliberately. But when something happens like this. About 2 years back, I had to make a will. That person joined KE, where I am a member. And in the first meeting, he asked me, is there any cancer specialist in this association? I said, yes, here is a cancer specialist. I introduced him, then I forgot. In 15 days, he came back to me. Robinson, I want to make my will. Okay, I'll help you. He gave me all the details, drafted his will, showed in the will, he approved it. As per his wishes, I did it. And one day he said that it has to be done urgently because I don't want to take risk. All right, it's ready. You already approved. Tell me a date. And he told me a date. He has to get admitted into hospital, he said. Friday. Friday, as Mr. Bosco knows, it's our day in Toastmasters. After Toastmasters KE meetings. After that, 8:30, I told him, 9 o'clock you come home.
In the night.
In the night. Because he was staying very close to my house. And during daytime, I was not free. Then I requested him to come at 9 o'clock with the witnesses. Will was ready, drafted only for signature. That day, 8:30, I was back home. Then everything was ready, kept prepared. But it started raining. Heavy raining on that day, at that time. After the rain stopped at 10:30, I telephoned, I am waiting. Please bring your witnesses, everything, sign and go. In that case, he had told me, while engaging me, he said, sir, I don't have any money to give you. I said, all right, I don't charge you at all. As a community service, I'll do it. He's helping, come. Night, I telephoned him after the rain stopped. Then he sought a few minutes time to contact the witnesses, then came back to tell me that witnesses are not ready to come now, it is too late. Then I told him, we'll do it, I'll change the date. Whenever you want, I'll do it. No, Robinson, we can't postpone it. Tomorrow I have to get myself admitted to hospital. Same doctor whom I had introduced, hospital. I want it to be done in the night. Then I told him, don't worry, there is a solution for any problem. Give me half an hour time, I'll come back to you. Don't go to sleep. I'll solve your problem. Then I telephoned to the doctor, because he had told me it's the same doctor. I knew him, that doctor. Explained to him the situation. Sir, I will email the will. He has already approved it. Please take its copy. Let him sign in your presence. You sign as one of the witnesses, attested witnesses. And let another doctor observe both of you and let him sign it. Yeah, it was done.
Excellent.
It was done. They signed it. But this person never regained his consciousness on the next day. He died.
So he died before the operation?
During the operation.
So his will was signed?
Will was signed. Will was signed.
Excellent. Yeah.
Mind's Mass, I had gone there. The widow held my hand and took me to all the relatives. This the lawyer who saved my family. This the lawyer who has saved my. I didn't understand what she was saying. I didn't, but I just smiled on her face when she was praising me. And then I came to know after 15 days, that person had another son and nothing was given to that son. Equity and equal distribution. Then I came to know that son had not attended his funeral. He was always fighting with the father, creating problems. Didn't come even to the Mind's Mass. Father, do you think that equity must be there? Equal distribution should be there? Can't be. It's a choice of the parent. It's their money, their assets. If they don't have the right to give, then that's why will is made. If it doesn't make a will, then Indian Succession Act comes. There, 1/3. For every community, there is succession laws are there. Hindus. Indian Succession applies for Christians and Parsis. For others, Sharia law for Muslims, different types of will. They are there. They have the free. It's their property. Parents have the freedom to distribute. That's why that can be done only under the wills. That's why wills are necessary.
So that,
particularly in this type of cases.
So that brings me to a related question, right? So on one side, we're talking about my personal right, and the second is the right of me as relation to my family. So in the cases of joint will, my husband and I make a joint will, and one of us passes away, right? And then I live for another 25 years, right? And in that time, the situation has changed. Like Father Joey said, at that point of time, and this is both a legal question as well as a moral question, do I uphold my intention with my spouse? Or do I let the next 30 years of my experience allow me to change my will and make a new will?
Very interesting question you have asked. You and your husband have made joint will. Your husband is no more. He has passed. The joint will has come into effect. You are going to live for another 30 years. You can't touch that will at all.
You can't touch a joint will.
You can't change that will at all. Because that will has already come into force. You can't modify it, amend it. That's why we should avoid making a joint will.
I think that's a very good one, guys. Yeah. I thought I could actually then change it, right? Because I have to be fair to what happens later. Okay. So that...
Yeah. I think you will do it tonight.
No, this is not her story. This is only hypothetical.
Yeah.
It's about Alex.
Yeah. Because the whole point is, he stated at the very start that it makes sense every 5 years to review your will. Because things change, situations change, new factors come. And I think it is to make it relevant. It's not written in stone, as they say. It's written so as to respond to particular needs at that moment. You might have accumulated more, or you might have lost so much more. All that has bearings about how you want that to be spent, used, or given as a legacy or heritage to the others.
So one of the other questions I had is, the responsibility for an executor sounds quite grave. An executor has to do a lot more work than just be and legal. He may or may not be a legal heir, but it's a lot of work. So what are the qualities you look for in an executor, other than the fact that them being in the same city helps? What else do you look for when you name an executor?
First, you must take his consent. Second, he must have time to attend all these things. Select a person who commands some respect, from the beneficiaries. So if there are anything amiss, he can bring about. He can't change the will, but he has to give effect to the will, terms of the will. So among this one, while distributing these things, so he pacifies and distributes what is there mentioned in the will according to that one.
And similarly for witnesses, what kind of?
Witnesses, they must be younger. Their responsibility only to see you signing and they signing. That's all, nothing more. and they will be questioned at that time. But they also must start. Tomorrow they shouldn't say, I was not there, I signed some other papers.
That's
That
what I'm
happened
saying.
recently in a Supreme Court case, very recently.
So that's
Yeah.
an interesting one. So if I see
But
someone
he
attesting,
must be a younger one, and he must survive you.
so legally, I'll see the person attesting his will. It is the last sheet,
Yeah.
right? And then I say I've seen this, but I don't know what are the first 3 sheets, right? So on what basis do I say yes, this is the one? Do I put one secret mark? What is it? How do I know that this is the one? The last
That-
sheet can be also
No,
replaced, right?
he makes a statement there.
Hmm.
Witnesses sign before a statement. In that statement, last para, you are not read it. In that para, he says, I have seen the testator signing these pages.
He signs all the pages.
Testator has to sign all these pages.
So he
in
will
my
witness
presence.
the signing of all the
Witness
pages.
signs at the end. And
Yeah.
in my presence, they are signed. That's all. Witnesses need not know the contents of the will. No. Need not know the contents.
So he has to see the testator sign
Signing.
each and every
Each,
page
yeah.
without seeing the content, and then sign the last bit and say this
Yeah,
is valid.
yeah.
Correct. Okay, got it.
No,
Are there any
he doesn't
questions?
say this is valid. He only sees
is the will I signed.
testator and he signs.
I just want to, since you mentioned this whole thing about the joint will which he cleared, I want to take it a little further. Just, we are giving a tragic situation, hypothetical. Husband and wife, a young couple with 2 children, 15-year-old and a 12-year-old. Sadly, the plane has crashed and they expire. Now, there is no legal document because the husband had made it in favor of his wife. But now both have gone. So how will you respond to the situation of 2 orphan children, but now without the benefit of the documents to protect their interest and to inherit their legitimate property?
There are 2 aspects here. While making such a will in favor of his wife, normally there will be a clause. If both of them die in circumstances or wife dies earlier, of course if wife dies earlier, he can make a fresh will. Even then, there will be a clause how the property will be distributed among the 2 children, minor children. Of course, if say, let us take, such a clause is not there. Parents are not there now, they have died. Minor children are there, 15 and 13 you said. Then Indian Succession Act comes into force. The property will never remain orphan. The children will remain orphan. As per the Indian Succession Act, the children will succeed to the legal heirs will succeed to the properties, assets of the parents.
Therefore, I think that what you said makes it so urgent, so important for everyone to work on a will, no matter, don't wait till you're 40 or 50 or 60, but to do it now and to check all the various angles that might be involved. We're not asking you to think morbidly, but to think realistically. We all like to live forever, but nobody wants to get old. So, and I think it's so important that to protect not just our interests, but the ones whom we love. Because actually the will is a form of communication between the one who's died to the ones who are still living. And it's therefore not just a legal document, it's a document of love, where we are protecting their interests, not only in life, but also after we have died. And I think that's important to highlight.
So coming back to...
Once again, I will clarify one more point. When a will is made, the person doesn't lose his right on the properties.
Yeah.
He continues. He can change it any time, modify it, make a fresh will. He continues that. It comes into it only on the death. So it is necessary, absolutely necessary, with the example I have given you, make a will. You can change it. You don't lose right on property. It's still yours there. It safeguards your children, your successors. They will be knowing where the documents are there, what are the documents, where the investments are there, which bank, which accounts. PPF. If you don't make a nominee, whatever the amount is there in the PPF account,
goes to the government.
you will get only 1 lakh. The rest of the amount goes to government.
If you don't mention it in your...
If you don't make a nominee. If you make a nominee, you can, otherwise you have to make in the will. Will overrides nomination. Even if you think that I have made a nominee for the PPF account, so if you know, nominee will get it. Nominee has to distribute it among the legal heirs. If you have not made a nomination in the PPF account, no will, the legal heirs will get only 1 lakh. The rest of the amount in the PPF account goes to government.
So you're advising that when we make a will, while taking care of a legal heir, we also mention if the legal heir does not survive this condition, what it goes to next. Like if I'm giving it to my wife and she doesn't survive the will when it comes in, then we should keep a condition for the person not surviving.
You can mention it in that
I got that.
will. You have to mention it. Or wife dies earlier, husband can make a fresh will.
Fresh will.
Fresh will. It's possible.
Mr. Robinson, how does a witness know that the testator was of sound mind when he signed the will and was of the right mental capacity when he did so?
Witnesses will be selected by the testator. He brings the witnesses. And in the will, the testator first itself makes a statement that I am of sound mind and health. Important, sound mind is important there. So when he himself selects the witnesses, we lawyers don't select. He brings them. Then they should be knowing that he is of sound mind. Apart, if we doubt, then we request the testator to get a medical certificate from a doctor. That I have done in 2 cases, I have done it. And I attached that certificate. I mentioned that there is a medical certificate attached to it. In the will, I mentioned at the end. Like that, that's safeguard we take.
So connected to this, I have a question that I'm making a will because in case of my demise. Now there's also a situation that we're all living longer, right? And we're all living longer physically, but mentally we may not be living healthily, right? So how do I protect myself in my will so that in case I'm not of mental health after a period of time, how do I protect myself? Is there a way? Have you had cases like this?
No, I didn't have a case like that. But one thing, you make a will, that will become enforceable only on your death. Better you the person makes a will, make it at an early stage. For example, 35, you can change it any number of times. Don't postpone it to make it at the last stage. That will be doubted.
So that comes to the question of the living will. What is the difference between a living will and a legal will?
Living will, for example, so far we have spoken about the legal wills. Those wills will come into effect after the demise. Living will means, example, I am sick or I foresee something wrong with me. So I make a living will. Now about 1 year back, Supreme Court has passed a judgment. According to that, it has liberalized the conditions to make a living will. I make a living will authorizing the doctors not to prolong my life putting on tubes and all if I come to a vegetative state. Let me share you an incident that happened of my friend, my neighbor. He worked in a bank as a manager, retired in a very superior post in that account. His 2 children, one a doctor, another engineer. Both are now in United States, at the time also. Here, husband and wife. But he was a different type, had a different type of attitude, very strict, aloof, never mixed. But he had to mention, if I fall sick, take me to this hospital. One night he fell sick, unconscious. He was taken to the hospital. He had not made a will. Then he had to be put on life supporting tubes and all. Since he had not made a will, his wife had no information of anything about bank accounts and all, though wife of a manager. She had to struggle to get money to pay to the hospital. In fact, my wife that day signed the hospital papers for his admission and all. Wife was running, had to go to the bank to get the money. She was not a joint holder. She had no bank account, nothing. Luckily for her, that person had worked in that bank and those people knew him. They came to the hospital to see him. Then they released the funds to her. Imagine the flight of not making will. And he was there for 21 days. They spent 24 days. He was on tubes. Continuing. Then the doctor said, this is the best we can do. Now he will survive, provided he is put on oxygen support continuously, and there must be one person to look after him throughout the day. By the time son came and said, no doctor, enough, please put him in the special ward. 5 o'clock he was shifted to the special ward against the doctor's advice that they take it for the safety. 7 o'clock he expired. What happens? No will. Imagine the fright of the woman, wife. Money was there. It can't be withdrawn. And the hospital, they have not started the treatment until the money was paid. And 24 lakhs were spent, to my knowledge, for 21 days to take care of. And living will, we make the will during our lifetime. That will, just to say, if I fall sick and there is no chance of my recovery, I should not be continuing on life support. This will separate from regular wills. This will has to be made before, attested by a gazetted officer or a notary. My physician, when I am sick, will tell the hospital that Robinson had made a living will. Then hospital superintendent has to appoint a committee. Whether that committee will decide whether I should put on life supporting tubes and all those things, food and air. If they don't agree, then if I am conscious, if I am, I can file a case in the Supreme Court, the High Court, challenge it. Or my legal aids can challenge it, my family members can challenge it. If they agree, then my end will come. And that was my wish. That's what I have declared to them. That's a legal way.
Okay, just to...
Here, property is not involved, only my life, continuation of my life, whether I should live on tubes or not, or they can bring an end to my life.
Just to recapitulate what we have done on an earlier program, especially episodes 13, 14 and 15, we dealt with the living will in great detail, because living will, as rightly pointed out, applies to what kind of process and procedure when we are still alive. The legal will happens only after you are dead. Now, it's very clear, I just want to affirm, as Catholics, we do not believe in euthanasia, so there's no pulling of the plugs. But there are certain clear moral principles where the kind of treatment that we have, where the burdens outweigh the benefits, where you are not obliged to do extraordinary means, there are certain moral principles. We just don't want to do it because it's the most convenient thing. But respect for the person, respect for the moral principles, and to do it with good faith and good understanding. Because sometimes one might say that this is not going to, we looked at it in great detail. Somebody has got cancer, they start the chemotherapy, and after a while they say the treatment is worse than the disease. Let me gracefully pass away. Euthanasia is when you actively promote somebody to die. This is you let the disease takes its course and you die as a result of that. So I just want to make that clarification from the Catholic point of view very, very clear. And thank you for introducing the topic between contrasting the living will, operative as long as you're still alive, and the legal will that's operative only after you die.
So then in the living will, so there are 2-3 aspects that come in. One is maybe I may do organ donation. I may choose to do organ donation. I may choose to give my body as a cadaver for medical research. Now in that situation, I have died. So how do the people who are supposed to give organ know that they're supposed to come? Because it has to be done in the first 6 hours. And 2, how do we make sure that the cadaver request is carried out? Because there is obviously going to be family emotions about both these cases. So have you any points of view on that?
You mentioned the organ donation has to be done within 6 hours. It is true. That applies to eyes. If the eyes are not extracted within 6 hours, then they will become useless.
Yes.
I have 1 or 2 experience in this case. You have to register first if possible for eye donation, but it's not a must. And particularly for your body donation, cadaver donations, you can. You also mentioned that your family may agree or may not agree. In one case, a person requested to make a will. I made the will. He wanted to donate his eyes. It was done, but we didn't inform. Then within 3 months, he had liver cancer. Possibly he anticipated it. I never expected of him having liver cancer. Purely vegetarian, non-smoker, no drinks, no alcoholic, nothing. But say he was lonely person. His wife had died earlier. Then on the night he died in the Manipal hospital. In the night, his daughter telephoned me, Papa, Uncle Papa is no more. He died. Then suddenly I asked her, do you know he has made a will? Yes, Uncle, I know about it. Then I kept quiet. After a month, I went to their puja. Then the driver brought and gave me cover. ಏನಪ್ಪ ಇದು ಸಾಹೇಬರು ಕೊಟ್ಟು ಸರ್ ನಿಮಗೆ ಕೊಡೋಕೆ ಹೇಳಿದ್ದಾರೆ, ಇಂಥದ್ದಾದ್ರೆ ನಿಮಗೆ ಕೊಡೋಕೆ ಹೇಳಿದ್ದಾರೆ. I opened it. It was his will. In the same situation which I had given in a sealed cover. Organ donation failed. Children didn't know it. He had not disclosed. See,
The will has to be read as soon as the person dies then, right?
It will be used because they will. No, there is no rule of that.
Then how do I know I'm supposed to give the eyes for? Then the living will.
He must have informed.
Okay.
Here he gave it to his driver. He kept it. And he had instructed the driver to give it to me. When a situation arises, he promptly came and the puja time gave it to me as a gift. I still feel for that. The wish of that person to donate. First register. One. You are not registered eyes, you can donate. Because we lost my brother, a younger brother, 10 years younger to me, in October last. We donated his eyes. No preparation. They just told us, hey, your brother is he won't survive, cancer. He won't survive. Can we have the eye donation? Immediately we give the consent. Because it helps 2 persons to get eyesight. Cadaver donation, you asked. We had to register it earlier. During COVID time, no hospital was ready to accept any cadaver. But cadaver donation register, I was connected with one hospital. Then those people came to me complaining against an official of the hospital. This person in charge of mortuary, he was telephoning every week. How is your father? How is your father? They were frustrated. He was alive. Because when he dies, cadaver will be brought there. He will clean in that one and dress the corpse. He doesn't do it free. Even it's a private hospital. There he used to earn money. It came out. That other nuisance will be there.
They'll call you regularly to find out when you're available.
The experience you have to share it. It happens. If your family resists. We have made a will. I have made a will. My wife has made a will. We have expressed our cadaver to be given, donated to hospitals for research work. But of course, my children has opposed. We don't want that one. But we have made that one. We are not informed the hospitals, but we are informed in our will. We don't know. We will not be there when it happens. Whether they preserve, because they will have to take a decision. By that time, we don't know. Our wish is for donation.
But that brings me very interestingly to the will reading. See, rarely the will reading is done when the person dies. It's normally after 3-4 days. So if I write in my will, I want eye donation on this, that opportunity is lost because the family is not in a state to listen to the reading of the will. Then it has to be in the living will.
At least someone in the family must be aware of what is. Someone in the trusted person who keeps it secret must be aware of this.
So the living will is a good one to
about these things. Living will is different. It comes into effect during lifetime.
But is it advisable to put it there as well? Because living will be at the time of death. So they are also aware that if the person dies, I have to give. Because
No,
The legal will, unless I
only,
discuss.
living will only to the hospitals, to not to stretch our lives when we are in a vegetative state. No chance of recovery. All these things have to come. And you can write in advance, but inform some trustworthy people. But if you disclose everything in the will to them,
Yeah.
then there may be a problem.
So this condition we
our
should
death
declare.
may come faster.
Yeah, so this condition we should declare. I mean, it's advisable to declare. Okay, got it.
Inform them that this is my wish. Finally, it's for the family members who love us, whether they may have their own.
Father, we were now talking about cadaver, giving the body to the hospital for their examination, for their investigation and for their studies, for the students. Now this has to be done in a hospital. Now I'll give you an example of my own case. My wife and myself have donated our bodies to Ramaya Hospital. Now, it has to be witnessed. The document we have to sign before the hospital is, we have to be witnesses. I asked my children, they said no. So I got 2 other witnesses, one my brother and somebody else as witnesses. And of course, it was brought to their knowledge that this has to be done. And I had informed a nephew of mine that he must take care of it because my children are not going to do this. So this awareness in the family is also required. So moment, of course, we are all there when my wife died. And we informed the hospital. And we also said we have to have the mass, we have to funeral mass and all that. It will take time. They said the body must be kept in a ice box. We had that thing then. We had a mass. The hospital van came to the church, waiting for us, and they took the body. And of course, I had to accompany the body with my others. Then we did. So that is possible. It is the family is aware of it.
Correct.
That is important. That's what I'm trying to say. They are aware of it. And even another one more point you raised was the medical, of course, that thing that we have already touched on, that other subject, living will. I just wanted to mention to you, the father also said, you can't take away the wires, somewhere you said. Here, same case in my wife's side. She a patient of cancer. The doctors had said 4 weeks. She was going for chemotherapy, etc., etc. She collapsed in the house and she was not breathing. We had our oxygen concentrator at home. With that, she was not able to breathe. We had to rush to the hospital, Manipal. Then 3 of us, my son, myself, my daughter, we had to decide how long are we going to keep her in this state. Because I knew at least, and the children also knew, that she's gone. Physically, she's gone. Only medically, they are allowed to keep her. So, we said, 24 hours we'll see. Doctor said, we will keep it for another 24 hours, 48 hours. We said, that's it. So she was on oxygen. She was on ventilator. And there was some other thing, dialysis. Dialysis also was there. Then when we decided that is the end of it, the doctor in charge of that ward, he said, what you have decided is right. So we were allowed to go spend our time. So she was not conscious. She was not conscious. What conscious? She was at home the last few minutes in the morning. That was it. But she was breathing. Breathing is through ventilator. And in fact, we were saying prayers, singing, all. It was like we had our own time, like a family we had. But at a certain time, when my son was saying the prayers, she paused. The nurse who was in charge, she said, sir, but she didn't want to disturb him. But at one time she had to. She said, see the instruments. Instruments are closed. So this is how the hospital. So it was her desire? No. We had to decide. Now living will. She had not decided to stop our medical treatment at one time. But we, the members of the family, of course, being a small family, we could decide what to do, what not to do. But this is permissible. Father, you have to...
Yeah, we've dealt with this already in
Yeah,
3
I
episodes, 13, 14 and 15.
Yeah.
Thank you for sharing.
Thank you for the various sharings and the experiences that we've just listened. I think it highlights an important point of what we've already done before. While this is a talk show, it's true, but we also share very deep moral principles of the Catholic faith, how these issues have been addressed. And therefore, I would recommend that you look at episodes 13, 14 and 15, which deal precisely with some of the issues that some of you might have had. And it's good to revisit those links and look at what the living will is and what do we do in situations that some of you will find so challenging and difficult, especially to see your loved ones suffer, and what's the best way to care for them at that time.
And that brings us to the end of our second episode of Legal Will. I hope you enjoyed it. Don't forget to like, subscribe, comments, share it with friends, start thinking about it. Signing off from your favorite talk show, Aging Gracefully, a talk show for Evergreens.
This is a talk show, it's true, but we also share very deep moral principles of the Catholic faith, how these issues have been addressed. And therefore, I would recommend that you look at episodes 13, 14 and 15, which deal precisely with some of the issues that some of you might have had. And it's good to revisit those links and look at what the living will is and what do we do in situations that some of you will find so challenging and difficult, especially to see your loved ones suffer, and what's the best way to care for them at that time.
I get some Facebook reminders of a friend of mine who's passed away. It scares me, but sometimes it pops up saying she's, saying hi or whatever. And then, so that probably means that they have passed on the digital assets with the account management to somebody in the family.
There is a restriction so far as Indian Succession Act is concerned. All entire property should not be given to charity. There is a restriction. It is possible to establish a trust. Certain percentage of this one can be given for the trust, and a provision may be made in this one. When the will comes into effect, straight away that money will go to the trust.
After your death, that's the legal will. So actually it's a marriage of two things, of your passion for the world, passion for justice, passion for the poor in society is manifested not only in your life, but it's continued even after your death. So it's a continuum.
If one has to make a will, he has to go to a person who has some experience of the thing.